funny.
Hello viewers, welcome to our program on immigration and you. I am your immigration attorney Michael Phulwani, and once again we have with us attorney David Nachman, my partner.
Thanks so much, Michael. Always a pleasure to be here with you.
आज का ये प्रोग्राम बहुत इम्पॉर्टेंट है. जब बच्चे 21 साल के ऊपर होते हैं, पीछे रह जाते हैं, तो उनके क्या प्रॉब्लम्स हैं, क्या हो सकता है, उस बारे में आपको बातचीत करेंगे. Before that, we will be talking about CSPA, but before that, David wants to talk about his trip to India next month.
Oh, and maybe you can also tell them in Hindi.
Yeah, basically, क्या है कि David Nachman जी जो हैं वो जा रहे हैं ग्रुप ऑफ इमिग्रेशन लॉयर्स के साथ. एक मीटिंग्स हैं वहाँ पर सभी अमेरिकन काउंसिल के साथ, और वहाँ करीब 3 वीक के करीब रहेंगे, जिसमें बॉम्बे जाएंगे, दिल्ली जाएंगे, चेन्नई जाएंगे, वैकेशन के लिए थोड़ी गोवा भी जाएंगे. अपने बीवी को भी साथ ले जा रहे हैं, इसीलिए मैं इस टाइम नहीं जा रहा हूँ उनके साथ. हम दोनों साथ जाएंगे फिर जनवरी के अंदर. और इसका मतलब क्या है, पर्पस क्या है कि आपको बताने का कि अगर आपको कोई भी रिलेटिव्स हैं, फ्रेंड्स हैं जो डेविड से मिलना चाहते हैं इंडिया में, तो हमें कांटेक्ट कर सकते हैं. और अगर मेरे को भी कांटेक्ट करेंगे और उनके ऑफिस को ईमेल करेंगे, कॉल करेंगे, तो आई कैन आल्सो reach David to get an appointment for them to have a consultation. So briefly,
exactly, and I'll be spending some time in the Mumbai. I understood, my Hindi is getting so much better, Michael. I understood everything. So please, if you, your friends, your family, anyone needs to have a meeting in Mumbai, in Chennai, in New Delhi, in Goa, I'll be happy to meet in Goa. Please feel free to give us a call, send us an email, and we'll set up a meeting with you. In addition, I'd like to remind everyone, we've been telling you on our programs on a weekly basis, please come to the TNEC International Film Festival. NPZ Law Group will be sponsoring English Vinglish, the excellent Bollywood movie, which I've seen several times, but we'll always love to see it again. And we will be sponsoring the movie at the TNEC Cinemas on Sunday, November 17th. If you need any information about attending that film, please feel free to email us and we'll be happy to give that information to you.
Okay, let's start the subject. CSPA, Child Status Protection Act. Let me go back many years ago. Once upon a time, the law was that if a family is coming and the children have crossed the 21 period,
21 years of age.
21 years of age. And like a brother filing...
Age out. That's what it's called, aging out. Right.
So citizen brother filing for a brother, and the brother's wife and children will come. Only those children who are under 21 at the time of getting the visa.
Qualify.
At the time, not filing.
Right.
They could not get the visa.
Right, and so the way that it would shake out in a normal case, Michael, is that we would get this call from the clients, oh, my son is 22, oh my God, what do I do? Will he be able to get the green card with the rest of the family? And so what would you say?
Not only at the time of getting the visa, I have a real case that in 1 minute I will tell. At the time of arriving in the US, I had a case where there were 2 twin girls, and they may be watching today on the TV or not. It was about 10-15 years ago. More than ago. So then these 2 girls had some problems, and the case was kept pending, delayed like it happens now. At that point, I had some very good contact in the Department of State. I won't tell his name. I approached him. I said, these 2 kids are getting age out. The council is still not working. He says, I don't believe it, because we have told them these are priority cases.
Right.
He picked the phone and talked to the council and gave them the information. Within 24 hours, 2 days, they called them, both give the visas. Now, visas, but they got a ticket. They couldn't get a ticket within 2 days, 3 days it took them.
Right.
When they were in the flight, they crossed 21 in the flight. They reached Kennedy Airport. Kennedy Airport, he says, you are 1 day late. Today you are over 21. Yesterday you are not.
What happened?
They put them in proceedings. They put them in proceedings. And the case went for a long time because it was maybe some other state where the proceedings were. And so later on came to know that something worked out. and probably they got married or something.
But it's crazy because it's such an artificial conclusion to something that could easily be rectified by something like CSPA.
There's no at that point there was no provision in the law.
That's right.
It's not the officer's fault.
So the determinations were arbitrary. Yes. So in order to rectify the arbitrariness of the law, then the CSPA was passed. So tell us what the CSPA says.
Now CSPA, what it does is protects certain children who meet the eligibility requirements of the Child Status Protection Act.
Right.
So what it did, there were some complaints going on that the petition was filed, the child was under 21, but you took immigration, you took
so long
10 years
to process.
I mean, so the government said, okay, the law was made. Okay, what we'll do, we will give you that time, the time that you file and the approval. So you are talking about the immigration delay on the part of Immigration Service.
So Michael, let me just take 1 minute to tell our viewers. So what happens is that when you look at a CSPA case, you have to look at it within the context. There are two different contexts. One is you have your family-based immigration, and two is you have your employment immigration.
Correct.
So CSPA applies in both, and there are different rules. In the family-based immigration context, you have what Michael's referring to as this analysis that's done, and it's a calculation. And there are actually calculators available online, so you can do a calculation to see whether or not you are or are not protected by the CSPA. So let me just, that's my aside. So go ahead, Michael, I'm sorry.
So basically this is the law. It says, okay, if we can only do the calculation when the visa number becomes available, not before. So when people ask a question, visa number is still two years probably away, I say, my best guess is this, but I cannot tell you because this calculation is strictly based when the visa number.
Right, it's dynamic, it's moving forward, so you can't do the calculation until it locks in.
Exactly.
Right.
So basically what do we look at calculation? Date of the birth of the child. Then we look at the approval notice to see when the petition was filed, when it was approved.
Exactly.
And then we calculate the day
you back it out.
The visa number became available and what was the age and then minus that period. For example, let us say that the child was under 21 when the petition was filed and all that, and it took about 4 years for the Immigration Service to approve the petition.
Okay.
And at the time when interview came in, he was about 23 and a half or something like that, 23 and a half. So we minus 4 years, goes back under 19. By minusing that period, that goes. In some cases also, there is another 45 days available coming from the Patriot Act, which says that if those petitions that were filed before 9/11/2001 get extra 45 days, because at that point the immigration offices got closed and they couldn't process and the delays that took place. So there's a separate coming from the Patriot Act.
Okay.
So that's one requirement. The calculation that we explained now, there's one more requirement also.
Now that's on the family-based case.
Family-based.
Right. And in the employment case, you lock in as of the approval of the I-140. So as long as the I-140 was approved prior to the time that the child turned 21, then you're going to be okay on the
basically again
side.
It's a question of when you filed the I-140 and when it got approved. So that period comes in as a, So it's not,
right, that's right, because you're going to have priority dates that are, you're going to have, right.
Only thing is frozen is the IR petitions. Any petition, EB5, any category which the visa number is available.
Exactly, that's where it locks in immediately.
So it locks in right there at that point. Right. So that's there's so many things there. But there's one more requirement to that. In addition to this calculation, you also have to show that within 1 year, from the visa number becoming available, it could be earlier also, but no later than 1 year after the visa number became available, you had to file an application for immigrant visa called Form I-230 at that time, which is now 260.
Well, I think that the way the regulation reads, if I'm not mistaken, is not that you had to do that, but you had to make an attempt to secure the visa. Oh, okay.
That's not, okay. It's not, the regulations are there, but this is a development coming from a court case.
Okay.
What you say. And we did something on that, I'll tell you.
Yes.
So that, if it's, and a lot of people, I'll tell you for some reasons, did not do that. Because the NVC never sent them the correspondence because
they never got it.
No. NVC sends only bills to those who are eligible. If they are aged out, they say we cannot talk to the consul.
Right.
So basically, they not even send a visa bill or any forms. So the people say, I never got anything from the child. So that's one of the problems. But that, what we did, we had a case where the form was not filed, but somehow they paid the fees. And the immigration says, the American consulate says, that doesn't mean nothing to us. The regulation only says if you file DS-30. Right. Then we went to the State Department. We said, referring to that court case, that more than an effort, we actually paid the fees. Are you not saying that we did not make the effort? So then, that was our first case, I believe, first case that our office handled at that time, close to that, where the Department of State...
Successfully, mind you.
Yeah, the Department of State told the American Consul, they thought about this, and then they came out with the regulation also.
Exactly.
So, two things must have happened, remember. So, therefore, you have the CSPA issue a child there, keep watching us the visa bulletin. So, when your visa number becomes, be proactive. And I see some of the cases that I see people come all the time, they moved from the old address to the new address, and NVC must have sent them a letter. They never got any letter at all. So we did not get any letter even about our own interview. Forget about the child. We are still waiting. I say, waiting means what? What's going to happen from the sky falling down? You made a mistake. You did not notify either the Immigration Service or the NVC or the American Consul that you have moved the address. They must have mailed the mail on that old address, must have gone back. And the question is, what can we do now? What can we do? I say, nothing much really. As of now, there are 2 or 3 requirements to how we can meet, but not every case. You must have either filed the 260 now, or you must have paid the fees. Third thing that can argue is that if correspondence was made by some lawyer or something was going on, in which you can show that you made
an efforts
and reasonable, good faith efforts,
reasonable efforts,
and then it still did not happen within the 1 year. So there are exceptions to that. Rule that we can go under the exception rule is the effort. What is an effort and when it was made and whether that will fly or not fly.
Right.
That will fly or not fly to that extent. But these 2 items are clear. Filing out 260 and the payment of the fees have been accepted now.
That's right. And it's likely that we may see that these issues of what is considered to be bona fide and reasonable efforts to obtain the visa will be tested in court. Yeah, so that's a possibility too.
Let's talk about a case. Nothing happened. CSPA is not eligible because of calculation, because of not filing 260, because of not fees. Nothing can happen. What would you do? You and me. We look at other options. The child is left behind. So if he had a good education, he got an engineer, he got a CPA, and we can then recommend an H-1B, for example.
Right. I think what you're saying is look at in the individual. Obviously, we would want to, if they're old enough, take a look at a resume. If they're studying, then there's a possibility that they could enter on an F1 to be with the family.
The consul will not issue an F1.
But the problem is going to be that they won't.
Consul will not give a student visa, visitor visa. But I'm saying options are H-1B is an option, L was an option.
L is a possibility.
EB1 is an option, EB5, investment of a...
And take a look at the O, depending upon what their resume is. Yep.
Investment of $1 million, $500,000, EB5 is an option.
Going directly into the green card. Of course.
And not only people say marriage, that means citizen, green card. How can I get it? No. Citizen, green card. Even you get married to an H1 guy, the person can come on an H4, he cannot work, but he's here with the wife and the parents.
Exactly.
And they can, we work with, you contact David Nachman and Michael Phulwani, and we can, they'll help them to get it.
So what Michael is saying is that there are options. Take a look closely at all the potential options that are available to be able to transfer to the United States to have this member of the family with you.
If the CIR gets passed, that says that the children in those situations when the parent comes in and files a new petition, now they are giving them the new priority date. Under the CIR, they will give them the old priority date of a parent, which will be many years ago. And with that,
which would be terrific, because that's what it's about. It's all about family unity under the CIR.
David, thank you very much for coming.
Thank you so much, Michael.
See how good information we give to our viewers, and
it's a lot and it's fast.
Yes. Thank you very much. आप सब लोगों का शुक्रिया बहुत. आप हमारे प्रोग्राम देखते हैं हर सैटरडे को, संडे को. प्लीज़ देखते रहिए हमेशा सैटरडे इवनिंग में और संडे मॉर्निंग में. बहुत बहुत शुक्रिया, धन्यवाद, एंड गुड बाय.
Bye now.